Today we gather to observe, I won't say celebrate, the 40th anniversary of Buckley v. Valeo, a landmark case remarkable for its impact and remarkable for lasting so long. This program, organized by Professor Gora and our exceptionally distinguished special guest speakers, is further proof of what has long been the case, that our great law school is a leading center for learning how to use the power of law to good effect for people and for our society at home and abroad. Perhaps you will understand, if not forgive, the great pride I feel as the president and dean of Brooklyn Law School, as once again it takes on issues which are paramount, whose significance matters far beyond our campus, our city, and the Empire State. Understanding Buckley v. Valeo and its progeny, studying election campaign finance law is critical to questions about liberty, freedom, equality, and the very legitimacy of our democratic republic. Our political election system is a shambles. Its damaged condition and disarray makes me think of a trailer park after a tornado. And like the harm of those terrible natural disasters, the man-made wind fanned by money, distrust, and partisan dysfunction has done serious damage, threatening the very foundation of our system of government. For our democracy to endure, it will require more than superficial cleanup and attempting to resume business as usual after each stormy election subsides. We need at long last a collective, community, selfless, public-spirited effort, and we need to completely rebuild our institutions on sound and safe ground. So before we turn to the gospel of Buckley v. Valeo, according to James, Ira, and Joel, three famous saints, prophets who were present at the correction. See, I know you don't read the sequel because prophets were in the Old Testament, right? And the Gospel's in the New Testament. So we want to get this technically correct. I stand by saints, three saints. St. James, Ira, and Joel. I will invoke two readings from Scripture. First, from the Old Testament, Federalist 51, Madison. If people were angels, no government would be necessary. If angels were to govern people, neither external nor internal controls of government would be necessary. Now, I know full well that Madison, who actually didn't say people, was talking about checks and balances and the structure of government to protect folks from abuse of power. But the lesson we can take for today's purposes from this reading, as we consider campaign finance reform issues, is we should keep our eye on the ball. And that is that elections are a means to the desired end of good government that is of the people, by the people, for the people, responsible to them and limited by them. That is our ultimate purpose, and today's program is but a start and will really nicely set up what might well be the most significant discussion of such issues in America this year. That is the Free Speech Symposium, organized again by Professor Joel Gora, with help from Judge Napolitano and our distinguished constitutional law faculty, that is set for February 26th? 26th. So stay tuned for that more fulsome discussion of the issues that you're going to have an appetizer taste of today. My reading from the New Testament is Brandeis, his great dissent in Olmsted versus United States. Brandeis wrote, "Experience should teach us to be most on our guard to protect liberty when the government's purposes are beneficent. People born to freedom are naturally alert to repel invasion of their liberty by evil-minded rulers. The greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning but without understanding." The lesson I take from this extraordinary passage for today's purposes is that it's not enough to assume and presume that one's cause is just, and that one side or other on the campaign finance debate has a monopoly of righteousness. We need to study all the facts. We need to discover what are the root causes of our problems. And we must take care, especially because so much is at stake, that our remedies are not worse than the disease. First, do no harm. Specifically, in my view, this is my personal view, the evils of corruption and tyranny that drove the advocates of the Federal Election Campaign Act and its amendments that drove the Buckley litigation, evils which indeed are anathema to our way of life, are less problematic than problems of asymmetry, which is to say inequality in the ability to participate and be heard, partisan dysfunction, which needs no explanation, as any of us who read the newspapers and watch the news can tell, and waste, which is to say that our campaigns are too long, too expensive, and too uninformative to do any damn good. And the biggest scandal is that politicians are compelled to spend their time and attention raising money rather than doing their jobs once elected. The good news is the fresh ground we can cover addressing these problems could prove to be very fertile, and I sincerely believe improvement is possible. Now, turning briefly to Buckley itself, it's an exceptional case. 143 pages, a per curiam unsigned opinion, a behemoth. 178 footnotes, 5 separate opinions of the 8 justices involved, writing more than 83 more pages, with appendices added, yielded a 294-page reported decision. By 2010, the year of the Citizens United decision, Buckley had been cited in 2,500 cases, 4,000 law review articles, and has been consistently cited in cases both upholding campaign finance laws and in cases overturning them. So questions I suspect our speakers will delve into today and begin to address will include, is the impact of Buckley v. Valeo what you expected? What explains its impact and staying power? Can we do better? And if so, what do you recommend? I am sure that we can leave some in-depth analysis of these questions to our upcoming free speech symposium, but for now, I really will refer to the Bible, citing Numbers, by asking, what hath God wrought? We have, like in Numbers, been wandering in the wilderness now for 40 years, and it's about time we find our way to a better place. And despite my dark opening comment about the reality of the terrible conditions of our broken election and campaign finance system, I'm an optimist and I have confidence which our country's history repeatedly demonstrates is warranted because of the resilience and powerful self-correcting mechanisms of our brilliantly designed, cantilevered system of democratic government, and by the strength and ultimate competence of the American people. Thank you very much. Joel?
Thank you very much, Dean Allard, for your typically probing and inspiring remarks to really set a perfect tone for the issues that we're going to be considering. Before I address those issues very briefly, I want to thank the Dean for his support for today's program, Linda Harvey and her terrific staff for organizing and publicizing the event, Stephen Ballou of the Student Federalist Society, and Kristen Hackett, Student ACLU Society, for co-sponsoring the event. Of course, our 2 speakers, whom I'll introduce shortly. Finally, I must pay public thanks to my wife of 50 years, Anne Ray Martin, for her unwavering support for my work on these issues for almost all of the years that we've been married, and to my daughter, Susanna Gore, for equally unqualified support. What brings us here today started almost 50 years ago when Congress passed the Federal Election Campaign Act. It was an effort to limit advertising of politics on television. It was hailed as a reform effort. It would clean up politics for all time, get rid of some of those problems that we had. And yet, the very first use of this law was against a group of anti-war dissidents who ran an ad in the New York Times criticizing the President of the United States. And for their work, they were sued by the federal government. And the government's theory was it was an election year, President Nixon was up for re-election, and therefore ads criticizing or supporting him came within the brand new federal election campaign laws. I worked as a lawyer at the ACLU at the time, and the people came to us. Ira Glasser will tell us more about it, and we were stunned. The idea that you could be punished, prosecuted by the federal government for public criticism of the President of the United States seemed inconsistent with everything we understood about the First Amendment, that it was designed to encourage criticism of government and not to stifle it. And so we were able to persuade the courts that if groups were not partisan groups, if they were issue-oriented groups, they should be allowed to engage in this speech without penalty. And so we breathed a sigh of relief, but then shortly at the same time, Watergate happened. You either remember or have read about it in history. One of the issues of Watergate was campaign finance irregularities, even though most of them were either already illegal or subject to disclosure. And the result of the Watergate campaign finance issues was that Congress passed amendments to the Federal Election Campaign Act. And these amendments were what gave rise to the landmark case of Buckley versus Valeo, and it was my privilege to have been one of the ACLU lawyers who argued that case in the Supreme Court. And the case challenged these massive new restrictions because what they did was they limited how much candidates could spend on their campaigns. They limited how much independent groups could spend to speak about candidates. They imposed broad and burdensome disclosure requirements on anybody who would speak out publicly about political or electoral issues. And to enforce all of this, they created a Federal Election Commission, which was appointed by the members of Congress. It was a situation of putting the fox in charge of guarding the chicken coop. Most people thought this was reform. We'd finally take care of all the problems of money in politics that the dean alluded to before. But fortunately, not everyone thought that these reforms were so great. Some people thought the restrictions on campaign giving and spending violated the very core of the First Amendment's protections of free speech as the engine of democracy. And so they organized a strange bedfellows coalition, and two of the leading strange bedfellows, we're so lucky, are our guests here today, of liberal and conservative politicians and groups to challenge these new draconian restrictions on political freedom. The plaintiffs included conservative Senator James L. Buckley, liberal anti-war Senator Eugene McCarthy, the American Conservative Union, and the New York Civil Liberties Union. The challengers claimed that as outsiders and underdogs challenging the establishment and the status quo, they would not be able to get their messages out without being able to raise and spend money from their supporters and in order to speak. The result of the case, of the landmark ruling, was that for the first time the Supreme Court declared that campaign finance limits violated First Amendment rights. It was a victory for freedom of speech and freedom of association, and it was anchored in the bedrock principle that the remedy for bad or difficult or problematic speech is more speech, not enforced silence. But as you will hear from our speakers, it was not a complete victory. While the court struck down limits on political expenditures as unjustified restraints on core First Amendment values, it upheld limitations on contributions to candidates because of the concern that they might lead to corruption or the appearance of corruption. And that split judicial decision would directly cause so many of the problems that we have in our campaign finance system today, including, most particularly, the rise of super PACs. And you'll hear more about that phenomenon from our speakers. Despite the fact that it was a historic but not complete victory for free speech, for 40 years, as the dean pointed out, it has provided the constitutional framework for the law governing the financing of our politics and the doctrinal platform for the more recent Citizens United decision, which has been as controversial, if probably more so, than Buckley. Both decisions have been harshly criticized, harshly attacked, but I think their core principle, that the people, not the government, get to decide how much free speech they want and need in order to challenge the government, remains an essential foundation of our democracy. Well, we at Brooklyn are so fortunate today to have two people who helped secure that principle as our guest speakers. Our first speaker will be Judge James L. Buckley. Judge Buckley graduated from Yale College and Yale Law School, worked in business for a number of years, and then in 1970 was elected to the United States Senate from New York as the Conservative Party candidate. I believe that was a first. In the Senate, he had a reputation for fairness and integrity, and indeed, he was the first prominent conservative senator to urge President Nixon to resign for the good of the country. When the FECA amendments were passed in 1974, the senator organized the landmark challenge to them, which bears his name. He was defeated for re-election in 1976 by a young academic politician named Daniel Patrick Moynihan, who would go on to become a great mentor and friend of Dean Allard's, who worked for him thereafter. Following a number of high executive branch positions, James Buckley was appointed as a United States Circuit Judge for the District of Columbia Circuit, and I believe he's one of the few people in the nation's history who has served, and with great distinction, in all three branches of government, as a senator, as a high-level executive branch official, and as a United States judge. And our other speaker is my longtime friend, ACU colleague, and campaign finance co-conspirator, Ira Glasser. Mr. Glasser, who is not a lawyer, was trained as a mathematician and taught mathematics at Queens College and Sarah Lawrence College. And then in the 1960s, he transitioned first to journalism as an editor at Current, a magazine of public affairs. And then in 1967, he joined the ACLU, where he worked for 34 years, 11 of them at the NYCLU and 23 as executive director of the ACLU. He retired in 2001 from the ACLU and chairs the board of the Drug Policy Alliance. As executive director of the NYCLU, he became involved in various cases challenging First Amendment violations by campaign finance laws and helped organize the Buckley case in order to protect the right to criticize the government and its officials without fear of limitation or reprisal. Judge Buckley and Ira Glasser will each speak for about 15 minutes, and then we'll open the floor to questions. So thank you very much, and I give you Judge James Buckley.
Thank you, Dean. Thank you, Professor. I'm delighted to be part of this commemoration of the 40th anniversary of Buckley v. Valeo, and not just because it has assured me a measure of immortality. Although the Supreme Court's decision in that case was flawed in one important respect, it warrants celebration because of the court's critical holding that campaign spending is constitutionally protected speech. The case challenged as Professor pointed out, challenged the constitutionality of the Campaign Reform Act of 1974, which, among other things, placed ceilings on what could be spent in presidential and congressional campaigns, and also limited individual campaign contributions to $1,000 per candidate, a figure that has since grown to $2,700, in case you're thinking about this coming fall. When the legislation came to the Senate floor, I felt its restrictions on challenges were constitutionally suspect and that they were very bad policy, and I vigorously opposed them. So when the act was enacted into law, the only resource was to test its constitutionality in court, and in this noble enterprise I was joined by a half dozen or so enlightened co-plaintiffs. At the outset, it is instructive to take a look at the plaintiffs in the case. What we had in common was not ideology, but our status as political outsiders. Although I was a United States Senator at the time, I had squeaked into office 4 years earlier as a third-party candidate. My co-plaintiffs included Senator Eugene McCarthy, who in 1968 had bucked his party's establishment by running a primary campaign effective enough to cause Lyndon Johnson to withdraw his candidacy for re-election. Other plaintiffs included the very conservative American Conservative Union, the equally liberal New York City's Civil Liberties Union, whose executive director here will be our next speaker, the National Libertarian Party, and Mr. Stuart Mott, a wealthy sponsor of liberal causes who had contributed $220,000 to the McCarthy presidential campaign. What we all had in common was a concern that the 1974 Act would effectively squeeze independent voices and reform movements out of the political process by making it even more difficult than it already was to raise effective challenges to the political status quo. We believe that its restrictions were fundamentally flawed both constitutionally and as a matter of public policy. The core values protected by the First Amendment speech clause is the freedom of political speech. It is incontrovertible that in today's world, it takes money and a great deal of it for political speech to be heard. Therefore, we oppose the Act's limits on contributions and spending as unlawful. We found the legislation equally objectionable as a matter of policy because a healthy democracy should encourage competition in the political marketplace rather than increasing the difficulties already faced by those challenging incumbents, all of whom enjoy such enormous advantages as name recognition, automatic access to the media, and the goodwill generated by handling constituent problems. Given this fundamental political reality, a challenger who is not a celebrity in his own right must be able to persuade both the media and a broad base of potential contributors that his candidacy is credible. This requires a substantial amount of seed money. As I testified in the case, I could not have won election in 1970 if the $1,000 limit on individual contributions had been in place. Thanks to about $60,000 in gifts from a handful of individuals, my campaign was able at the outset to hire key personnel, print campaign literature, and rent strategically located space in New York City for my headquarters. This caused the media to take my candidacy seriously, and that in turn enabled me to raise largely through the means of mailings the $2 million required for a competitive campaign. Nor could Senator McCarthy have launched a serious challenge to an incumbent president without the more than $1 million that he had received from a dozen early supporters. We won a number of our arguments before the Supreme Court, but lost a critical one. The court agreed that the restrictions placed on what could be spent in political campaigns were unconstitutional. It held, however, that the limitations placed on individual contributions was constitutional because of Congress's express concern for avoiding the fact or appearance of corruption in federal elections. But because of the understandable assumption that an individual cannot corrupt himself, the court overturned the limits that Congress had placed on what candidates could spend on their own campaigns. In the wake of the Supreme Court decision, we are left with a package of federal elections laws and regulations that have distorted virtually every aspect of the election process. The 1974 amendments were supposed to de-emphasize the role of money in federal elections. Instead, the limit on individual contributions has made the search for money a candidate's central preoccupation. When I ran in 1970, I never made telephone calls requesting money, requesting help, and I doubt that I attended as many as a half dozen fundraising occasions. Passing the hat was the exclusive concern of my finance committee. Today, from the moment they take office, members of Congress routinely spend an hour or two on the phone every day soliciting contributions for their future re-election campaigns. Federal campaign regulations have virtually driven grassroots action from the political scene. The rules have become too complex, the costs of a misstep too great. In 1970, when on campaign tours around New York State, I would often run into groups that, on their own initiative, had rented storefronts from which to dispense my campaign literature, man the phones, and dispatch volunteers. Today, anyone intrepid enough to engage in that sort of spontaneous activity must hire a lawyer, and even then he must be prepared to prove in court that he was acting independently of his candidate's campaign. Today's reformers complain that about the power of political action committees, the notorious PACs, and they do so with substantial justification. Those committees can have very specific legislative objectives, and they may condition contributions on a candidate's commitment to vote this way or that in future legislation. But their proliferation and growth are a direct consequence of the restrictions placed on individual giving. A citizen who would have contributed a substantial amount to a candidate in whom he believes, but is today limited to one of $2,700, will find other outlets for the rest of the money he has earmarked for political purposes. The PACs provide a ready alternative. There is general agreement that the current law governing federal campaigns is worse than unsatisfactory. The answer, however, is not to place further restrictions on the freedom of speech, as so many continue to urge, but to re-examine the premises on which the existing ones have been based. In the first instance, it has been amply demonstrated in a dozen races that money itself cannot buy elections. The voters have the final say. But what money can and must do is buy the minimum exposure without which no candidate, however meretricious, has a chance. Second, while it is of course true that large contributions can corrupt, the likelihood that a candidate will be seduced by them is vastly overstated. The overwhelming majority of wealthy donors back candidates in whom they believe and with whom they are in general agreement, and they are far more tolerant of differences on this point or that than are the PACs or other single-issue organizations to which a candidate must otherwise turn for necessary financing. Corruption only occurs when a legislator casts a vote that violates his convictions in exchange for financial support, and studies of actual voting patterns suggest that kind of corruption is far too rare to warrant the distortions created by the present law in an attempt to avoid the appearances of corruption. This is not to deny the importance of minimizing such appearances. Our current law addresses the problem by requiring the timely disclosure of all contributions over a specified amount. That enables opponents to publicize any gift that might give rise to an adverse inference, and the public can then judge whether the contribution, in fact, is apt to corrupt the recipient. I long supported that safeguard, but thanks to a recent dissent by Supreme Court Justice Clarence Thomas from a Supreme Court holding that the disclosures the disclosures of contributions is constitutional, I believe there may be a better way to deal with this matter. In his opinion, Justice Thomas described in chilling detail the organized harassment of individuals who had made contributions in support of a California referendum that would define marriage as a union between a man and a woman. He then concluded that he could not, quote, endorse a view of the First Amendment that subjects citizens of this nation to death threats, ruin careers, and damage to defaced property, or preemptive and threatening warning letters as the price for engaging in core political speech, the primary object of First Amendment protection. I'm no longer sure that I can either, especially given the power of today's social media to mobilize instant retaliation. I therefore believe that Congress should consider legislation to, 1, delete the limits on individual giving, while 2, requiring that all contributions be made anonymously. This could be done by requiring that they be routed through a neutral third party such as a bank. To ensure anonymity, however, the law would have to impose serious penalties such as mandatory prison time for any disclosure of a contribution source. But whether one discloses contributions or requires their anonymity, what makes no sense is to retain a set of rules that makes it impossible for a Stuart Mott to provide a Eugene McCarthy with the seed money essential to a credible challenge to a sitting president, or that makes politics the playground of the super rich who can finance their own campaigns. I recognize that congressional incumbents will instinctively resist my suggestion because the elimination of limits would make it easier for challengers to unseat them. I nevertheless hope that their liberation from the odious chore of daily pleas for money will incline them to oblige me. But only then will the Buckley versus Valeo plaintiffs be able to claim a total victory. Thank you.
I was struck, as I always am, by Dean Allen's reference to Judge Brandeis's line from the Olmsted decision about bewaring of men of zeal, well-intentioned but without understanding. Nothing provides a better aphorism for our subject today than that.
Thank you.
I also want to remind us that we're talking here about remedies. We're not arguing about the problem. It's a great mistake in public policy and in legislation to focus with almost hyperbolic intensity on the nature of a problem so that people get so excited about how terrible this problem is that they proceed to enact and support remedies that have no bearing on the problem and may make it worse and create other problems that didn't exist before. Lots of examples. In the 70s and 80s, rising crime was a big problem. So Ed Meese proposed to get rid of the exclusionary rule and the Miranda warning. And people bought that because they were so excited about the problem that they failed to notice that getting rid of those rights, A, would have no effect on solving the problem, and B, would create new problems by getting rid of rights that were very important to have. Alcoholism was a problem in the early 20th century that was runaway proportions. But prohibition was not the solution. The remedy not only didn't solve the problem, it created an immense range of other problems besides. It increased crime, it increased violence, it violated rights. The war on drugs only repeated that mistake, and it's still with us. So what you always have to look at when you're dealing with a problem, and the problem here is inequality of speech resulting from an inequality of wealth. Well, that's a problem that's been with us for a long time. Thomas Jefferson was hardly a man of the working class. And I grew up in this state where the names of the governors were Lehman, Roosevelt, Harriman, Dewey, and Rockefeller. And with the exception of Dewey, those four governors were what you might today call part of the 1%. I dare say they had more speech than my father, who was a construction worker with a fifth grade education, had, and certainly more access to the political system. And that's always been true. Whoever owned the Times had a lot more speech than I did, or than the people who owned the nation did. So inequality of wealth has always led to inequality of speech, and that's been a distortion and a problem in how democracy works, no question about it. But the solution that campaign finance advocates and the laws that they succeeded in passing, the remedy that they proposed, was to give the government the power to restrict speech and to equalize it. That was their theory. Well, as Joel said, the first time that was used, that power, when the government had it, was against these three bedraggled people who wandered into my office at the ACLU early one day in 1972. And, you know, we were always getting people who were half crazy walking in and wanting to be clients. And there was always a time where you had to sort of decide, you know, whether to just gently lead them out or listen to what they were saying. And the fact that they were crazy didn't mean that they weren't having their rights violated. And so these three people, they were all, I remember thinking how old they were, but they were probably about how old I am now. And one of them, the one who had the money, came in, you know, with his shirt open, and he had no, you know, he was half naked, and he came walking in, and they were carrying on about how the bombing of Cambodia, the secret bombing of Cambodia, and the war in Vietnam, and these were all unconstitutional, which they were, and how the war was being fought without congressional authorization, and all of they thought that this was the basis for impeachment, so they had paid for and run this almost unreadable two-page ad in the New York Times. It had a list of honor rolls of people in Congress who had voted against the war. They had people, dishonor rolls of people who had supported the war. They attacked Nixon. They attacked Kissinger. This is early 1972. And, you know, they published this ad. I remember seeing it. I looked at it. You know, I rolled my eyes a little bit at it and turned the page and onto the sports pages. And so why were they here? They were here because the United States government had gone into federal court in the Eastern District here and gotten an injunction prohibiting them from publishing that ad and prohibiting the Times from ever accepting an ad like that again under penalty of criminal prosecution. So I looked at that and I well, that can't be. First Amendment can't allow that. It's got to be a mistake. It's got to. So I read the injunction, and it cited this statute, which I had never heard of, called the Federal Election Campaign Act of 1971. And the statute provided a remedy for unequal speech in politics by saying that if anybody published an ad that praised a candidate, praised somebody who was a candidate for federal election, or was in derogation of that candidate's opponent, they couldn't do so without the money that they were spending counting against the limits of campaign spending against that candidate. So the candidate had to either certify that ad was his ad, or they couldn't publish it. So it meant that a group of citizens who had the money to buy the speech could not exercise their speech. This was criticism of a president and the conduct of a war in an election year. And if there was anything that the founders of this country meant to protect when they passed the First Amendment, it was that sort of speech on that sort of issue at that sort of time. So we represented them. We went into court. The case was called National Committee on Impeachment versus the United States, I think. And we won in the Second Circuit. And I thought, okay, that's it. You know, we slapped them around. That's the end of that. That kind of stuff was happening all the time, where public officials would step out of line and you win the case and it's over. Later that year, in September of 1972, we published an ad, or tried to, in the form of an open letter to President Nixon, criticizing him for opposing school busing for the purposes of racial integration. He had been a vigorous opponent of such school busing, and we were a vigorous supporter of it. So we published this ad in the form of an open letter to him, criticizing him and urging him to change his position. I didn't think there was going to be any more problem with that. We never got involved in elections. We were barred by our own bylaws from ever taking a position for or against an electoral candidate, and never had and haven't till this day. And you know, criticizing public officials is what we did. That was what the ACLU did. That was what most organizations like us did. So we submitted it to the Times. We raised some money for it. We submitted it to the Times, and we get a letter back from the Times saying they can't publish this ad. And they can't publish the ad because in the National Committee Against Impeachment case, they were threatened with criminal prosecution if they ever ran such an ad again. So I said, but we won that case. We struck that down. They were too nervous about it. They had this letter in their files. Their lawyers told them, better not do it. So we had a meeting with the general counsel of the Times, and we said, well, we're going to sue because the result of this is we can't speak. We can't get our position in the paper. We don't own the paper, so we have to buy the space. We're lucky enough to buy the space. We have the money to buy the space, but we can't buy the space. So, you know, you could write an editorial like this and be protected by the First Amendment, but we can't buy the space because of the government's threat to you that you'll be criminally prosecuted. So they agreed that if we filed that lawsuit, they would file an amicus brief on our behalf, and that's what happened. That case was called ACLU against Jennings, and we won that case too. So that was the second time within a year that the use of the campaign finance laws had been struck down and these were the first two, and to that date, the only two applications of the Federal Election Campaign Act of 1971. Not against big corrupt money people, against groups of citizens exercising precisely the right of speech at precisely the time it was intended to be effective, that the First Amendment was designed to protect. So we won that case, and in the course of these two cases, we discovered by the arguments against us that what the theory of the Campaign Finance Act was that any speech that praised a candidate or was critical of a candidate might affect how people voted. Even if there was no advocacy for or against the election, even if it was just an issue speech, which is all that the ACLU did and all that those three people who walked into my office 6 months earlier had done, it might affect the election, and therefore the money could not be spent on the speech without all of the restrictions that were built into the Campaign Finance Act. And from the beginning, at its roots, the original sin of campaign finance advocacy was the notion that any speech in an election year on an issue that was critical of or praiseworthy of a candidate for federal election might affect how people voted. That if somebody saw our ad criticizing President Nixon for his position on school integration, it might cause them to vote against him. And therefore, it was construed as a campaign act instead of as free speech. They kept passing these things in new forms, and we kept striking them down. And this has gone on now for almost 50 years. A lot of the provisions that were at stake in the McCain-Feingold Act were different versions of the same thing. In the limitations against speech by corporations, people had in mind, oh, they're limiting corporate speech, that's a great thing. We don't want Exxon and Chase Manhattan, and we don't want them affecting our elections. They don't spend money on campaign speech. Who spends money on campaign speech? Other corporations, like the ACLU Incorporated, like the NAACP Incorporated, and yes, like Citizens United Incorporated. Those were the corporations that ended up being limited and threatened by the legislation. Did it affect the money in electoral speech? No. Has the money in politics gotten worse or better in the last 40 or 50 years that these campaign finance laws have reigned? It's gotten worse. Has inequality been reduced in electoral advocacy, or has it been increased? It's been increased for reasons that have nothing to do with the exercise of free speech. And what Judge Buckley was saying about Gene McCarthy was exactly right. He became a big advocate of our position because of what had happened to him. He was running a quixotic campaign. When he started his primary campaign in New Hampshire, you know about New Hampshire, right? You're about to see it again. Why Iowa and New Hampshire affect anything in the country, I don't know, but everything in life is timing, right? They get to go first, so they get to get all. But he went into that New Hampshire primary as part of an anti-war effort to turn Johnson around. And when he started that campaign, he was, this guy from Minnesota. Nobody ever heard of him in New Hampshire. He had 2% name recognition and no money. Well, if you have 2% name recognition and no money, how do you run a campaign in New Hampshire? You don't. And so he ended up having, I think initially it was just three people who were giving him high six-figure or seven-figure contributions, all of which would be a crime today. Even under the Buckley decision, all of which would be a crime today. And without those, who needs money in that kind of a campaign? It's precisely the insurgent who is not known. How do you get the money? If the incumbents want to beat you, they make you collect it in small chunks, because that's almost impossible to do. And you need money to raise money. If you're going to use direct mail to raise money in small chunks, you need billions of dollars to fund a direct mail campaign. If you're going to do television advertising, you need money. The insurgents are the ones who need money. The incumbents don't need the money. They have the name recognition, they have the franking privilege, They have the ability to call a news conference and make news because they're already elected. The insurgents always are the ones who don't have the name recognition, don't have the visibility, can't be heard. They're the ones who need the big gifts. Without the big gifts, they can't get started. So McCarthy gets these 3 contributions. He buys time in New Hampshire. He gets known. He ends up coming so close in the primary campaign. He didn't beat Johnson, but he got so close that Johnson announces his resignation, and the whole tenor of politics and the war in Vietnam changes, which was, after all, what Senator McCarthy's goal was. If the current campaign finance restrictions, even after the Buckley decision, were in place, he never gets off the ground. No liberal in America objected to that at the time. All of the people who are against big money now and carry on about Citizens United were the ones who supported the Gene McCarthy campaign then. Always beware of whose ox is gored. As Judge Buckley said, what united this perception of the strange bedfellows in the Buckley case was that they were all outsiders. They were all insurgents running against the establishment. That is what united them. And they were all discriminated against by campaign finance laws. Joel, once early in his tenure at the ACLU, called the Federal Campaign Act, the amendments of '74, the Incumbents Protection Act. I think it was you who did that. And it's been that ever since. And incumbency has increased during the 40 or 50 years of campaign finance legislation. So has the inequality of campaigning, so has the inequality of money, so has the inequality of speech. The remedies of the campaign finance laws have not worked on their own terms. They have made the problem worse, and they have constantly been used by the government to attack speech that was not even an intended target of campaign finance laws. So when you look back at the Buckley case and what we did, that was the reason. We had won a few cases before, but they just kept coming. And so the Buckley against Valeo litigation was an attempt to comprehensively, finally, knock this thing out and reestablish the First Amendment. And if you were going to deal with the issue of inequality of speech and money in politics, you had to find a different way to do it. Maybe public financing, maybe giving candidates the franking privilege so that they had it as well as the incumbents. Maybe lots of things. Maybe deal with the tax structure so that the inequality of money didn't go out of control as it did. But the radicals who might be dealing with the inequality of the tax structure would rather deal with repressing the speech of the ACLU and the NAACP and Citizens United. What Citizens United did when it made that film attacking Hillary Clinton might have been what we did in making a film attacking George Bush. But because it was a right-wing group attacking a liberal, all the liberals thought that this was speech they'd rather not see. And finally, the one thing that one has to remember about all of this is that although the McCain-Feingold Act, which is the successor fight to what started with Buckley, if in the McCain-Feingold Act only related to speech on radio and television. If the court had ruled differently in Citizens United than it did and upheld the constitutionality of those restrictions, the government would have gained the power to ban a book. That question was directly asked of the government during the Supreme Court argument. If you could ban a film critical of Hillary Clinton in an election year, could you ban a book critical of her? Could you ban a book that praised her? Could you ban her own book? And the answer to all of those questions that the government gave was yes. That if the First Amendment allows you to ban the film that Citizens United produced from being broadcast on television, then it could ban Simon & Schuster from publishing a book that said the same thing. So the question always was, what's the remedy to this problem everybody is concerned about? Does the remedy achieve what it claims to achieve? No. Does it make the situation better or worse? It makes it worse. Does it create a whole other set of problems that nobody anticipated, the way alcohol prohibition did? Yes, it does. It creates a threat. And the main use of campaign finance laws, the main use over the 50 years that they've been in existence, since before Buckley, the main use has been to try to restrict the speech of not-for-profit cause organizations. It has never successfully stopped people like the Koch brothers, or Stuart Mott, or George Soros. I mean, George Soros spent $27 million in 2004 on these kinds of advocacy. Did you hear a single liberal ever complain about that? People in this country have always been supporters of free speech, so long as it was their own. And that is the lesson of what has now become the liberal dilemma. People of zeal, well-intentioned, concerned about inequality of speech, which is a valid concern, and so blinded by it that they have supported remedies that, if they're successful, will destroy them. The Nation magazine came out for a constitutional amendment to reverse Citizens United. What that would require, if they were successful, was rewriting the First Amendment. Who do you think is going to get injured by that? It isn't going to be the Koch brothers. It's going to be the Nation magazine and people like them. So this is wrong-headed. It is the kind of mistake that we made with alcohol prohibition. It is the kind of mistake we made with the drug war. And it has been the dominant liberal mistake in constitutional rights for almost a half a century now. And if there is a lesson to be learned by looking back to the Buckley against Valeo decision, that is the lesson.